Independent contractor or employee. One of the Obama administration's main goals is still to find and eliminate the practice of misclassifying workers as independent contractors. Audits have significantly increased, especially in the home health sector, and the IRS and the U.S. Department of Labor have stepped up their enforcement actions regarding worker misclassification. Following the signing of a Memorandum of Understanding allowing information sharing to combat misclassification, the DOL and IRS announced in September 2011 that they would be coordinating with multiple states as well as with each other. Legal tests for independent contractor status. Standards for determining whether an individual is an independent contractor differ, and misclassification can result in liability under a variety of laws, including labor, employment, and tax. Workers may be categorized as independent contractors by one agency or court after being classified as employees by another. Although the determination of employment status is a case-by-case resolution based on the totality of the circumstances, most courts consider the following factors to determine whether a worker is an independent contractor or an employee. The permanency of the relationship between the parties. The degree of skill required for the rendering of the services. The extent of the worker's investment in equipment or materials for the task. The worker's opportunity for profit or loss, depending on his skill. The degree of the company's right to control the manner in which the work is performed. Whether the service rendered is an integral part of the company's business, and any other relevant factors. Focusing on the home healthcare sector. Courts have taken a harsh stance regarding the classification of employees as independent contractors, and in the home health industry specifically, the vast majority of courts have concluded that under the Fair Labor Standards Act, FLSA, private duty nurses should be classified as employees. A recent example is LeMaster v. Alternative Healthcare Solutions Incorporated. In LeMaster, home health LPNs sued a staffing company that recruits nurses as independent contractors, and refers them to home health agencies and nursing homes to provide healthcare services to their patients. The LPNs also sued the company's owners personally. The evidence disclosed that the company interviewed, hired, and set the nurses' wages, as well as assigned the nurses their work, collected time sheets, and maintained personnel files. Based on these facts, the court determined that no factor favored independent contractor status, and several factors strongly favored employee status. Accordingly, the court concluded that the nurses were employees under the FLSA, and the staffing company and its owners were jointly and severally liable to the LPNs for damages. Other courts have analyzed home healthcare nurses and similarly concluded that private duty nurses, including LPNs and RNs, were properly classified as employees, resulting in large wage and hour damage awards to the plaintiffs. IN Crouch v. Guardian Angel Nursing Incorporated, in November 4, 2009, the court found that LPNs were employees of the staffing agency because they depended on the business for scheduling and job placements, did not make a sizable investment in tools or materials, and had their daily activities observed by the business for quality control. The court also entered a judgment for $2.2 million for liquidated damages and overtime back pay. In March 9, 2009, Gale v. Harry's Nurses Registry Incorporated, the court determined that LPNs and RNs were considered employees due to their crucial role in the company's referral of temporary healthcare personnel. Additionally, the court noted that the company maintained control over the nurses, including the ability to terminate them unilaterally and set their pay rate. Next, Wilson v. Guardian Angel Nursing Incorporated, July 31, 2008, judgment for $3.2 million for overtime back pay and liquidated damages. LPNs were found to be employees because, among other things, the company retained a considerable amount of control over the LPNs and thus controlled the manner and means in which they performed their job duties. Regulatory bodies and courts are keeping a closer eye on relationships between independent contractors, even though there is no one test that is definitive and each factor should be assessed in relation to the relationship with the workers. Before the federal or state government conducts an audit or a class action lawsuit is filed by a group of employees, all prudent companies that have a large number of independent contractors would be well advised to conduct an internal legal review to ensure proper compliance with federal and state laws. An ounce of prevention is worth a pound of cure, as the saying goes.